The envelope arrived on a Thursday afternoon. It had the family attorney's return address in the top left corner, which was how I knew it was not just routine correspondence. Randall Frost's firm had handled my family's legal matters for 22 years. Mail from his office was always deliberate. Always about something that mattered. I stood at my kitchen counter and opened it. My name is Isabella Crane. I was 31 years old that Thursday. I had been working in urban planning for 6 years, paying my own rent, managing my own life, doing all the things that children of complicated families learn to do quietly and without making a fuss. The document inside was 4 pages. Formal language. Numbered clauses. The kind that uses words like herein and whereas. I read the first page twice before I understood what I was looking at. My grandfather's estate, specifically the investment portfolio and the property trust he had designated for me in his will 12 years ago, had been transferred to my brother Diego. The transfer had been finalized on the 14th of last month, bearing my father's signature as executor. I was not named anywhere in the document except as the original beneficiary. The transfer had happened 3 weeks ago. I was reading about it now. My father's office was on the 4th floor of the building he had run for 30 years. I was there the following morning. I had not called ahead. I did not think calling ahead was something I should have to do when the subject was this. His assistant Owen looked up when I came through the door and said, "Isabella, but I was already walking past him. My father, Marco Crane, was at his desk. 64 years old. He had the manner of a man who has never been seriously surprised by anything. He looked up when I came in. He did not look guilty. He looked faintly inconvenienced, which was far worse. "I got Randall's letter," I said. "I see." He set down his pen. "Sit down." "I'd rather stand." He folded his hands. "I made a decision I believed was in the family's best interest. You transferred my grandfather's estate to Diego without telling me. The transfer is legal," he said. "That is not what I asked you." He looked at me for a long moment. His expression did not change. "It's better this way," he said. "You have always been capable. Diego needs this more right now." He said it the way people do when they have already closed the conversation. I left my father's office and drove to Diego's apartment. Diego was 34 and had spent most of the past decade between projects, investments that never fully materialized, and the general assumption that things would work out. Not because he was dishonest, but because he was my father's son in a way I had never quite been my father's daughter. I rang the buzzer. He answered on the second ring and let me up without asking why. He was in his kitchen when I came in, making coffee. He looked up and his expression told me he had known I would come. He had been waiting for this. "You knew," I said. He was quiet for a moment. "Dad told me a few weeks ago. And you said nothing." He set the coffee down. "What was I supposed to say, Isabella?" "No," I said. "You could have said no." He did not argue with that. He picked up his coffee and held it in both hands and looked at the counter. "The funds are already being structured," he said. "I've been working with an advisor." That was the part that landed hardest. Not that it happened or that neither had told me, but that Diego had already moved on it, without a single question about whether it was right. I drove home. I did not call anyone. I did not post anything. I made dinner and ate it and washed the dishes and sat at my kitchen table with a glass of water and the 4 pages from Randall Frost's office spread in front of me. I had always been the one in our family who managed. I had learned it early, the way children learn things that are never taught directly but are communicated through years of small moments. Nadia is fine. Isabella handles things. She does not need what the others need. That particular kind of invisible competence that gets rewarded with being overlooked. 20 years of that. 20 years of managing quietly, never causing a scene, believing on some level I had never examined that my father saw it and that it meant something to him. The transfer document told me clearly what it meant. I sat at that table for a long time. At some point the emotion of it moved through me and past me, and what was left was something quieter and more useful. Clarity, maybe. Or something close to it. I was not going to argue. I was not going to beg. I stood up and walked to the filing cabinet in my spare room and began to look for documents. My grandfather had left me a copy of his estate plan. He had done it deliberately, which I understood better now than I had at the time. He had given me the folder when I was 22, before he died. He said, "Keep this somewhere safe," the way he said things when he meant exactly what he was saying. I had kept it in the back of my filing cabinet in a folder labeled with his name. I spread the documents on my kitchen table next to Randall Frost's letter and read them in parallel. My grandfather's original estate plan was dated 11 years ago, updated once 18 months before his death. It designated the investment portfolio and the property trust specifically to me. The language was clear. The reasoning in a handwritten note on the back was also clear. He wrote that he believed I had the temperament to manage assets responsibly and wanted to ensure I had a financial foundation that gave me real choices. He had also written something else. In the distribution section, there was a condition. Any modification required written notification to all named beneficiaries at least 30 days in advance. I had received no notification and sent no response. I read that clause 3 times. Her name was Vivienne Okafor and she had been practicing estate law for 16 years. I found her through a colleague who had used her firm 2 years prior. When I called, she could see me the following Tuesday. I arrived with the full folder, my grandfather's original estate documents, Randall Frost's transfer letter, and a 3-page timeline I had made the night before. She read everything without speaking. She was the kind of person who reads with complete attention, no nodding, no whom, just reading. When she looked up she said, "Who handled the original estate planning?" "Randall Frost," I said. "Same firm that sent the transfer letter." She wrote something on her notepad. "And you were never contacted prior to the transfer?" "No. No letter, no email, no phone call. Nothing." She nodded once, a small nod. "Your grandfather's estate plan contains a standard beneficiary notification clause." It was not satisfied. She tapped the document. "That is a procedural flaw, and it is not a minor one. The transfer your father executed as executor may be challengeable." I had known this was possible since reading the clause 4 days earlier. Hearing a lawyer confirm it was different from knowing it alone. "What are our options?" I said. Vivienne walked me through the clause in careful detail. The notification requirement was specific. Any redistribution required formal written notice to each named beneficiary. The notice had to be delivered at least 30 days before execution, include the reason, the amount, and the receiving party. I had received none of that. "Your father is the executor," Vivienne said. "As executor, he has certain powers to manage the estate. But those powers are not unlimited. They are bounded by the terms of the original document. If he exceeded those terms, the action he took is challengeable. Would a court actually overturn it?" I said. "That depends on the strength of the procedural case and how clearly the notification requirement is written." She turned the page. "In this document, it is written very clearly. Your grandfather was thorough. He had been. That was exactly the word for him." "There is a second issue," Vivienne said. "The transfer document uses language suggesting you had knowledge of the redistribution. It says, quote, the beneficiary having been informed of the estate's evolving structure." She looked at me. "Were you ever informed of anything like that?" "No," I said. She underlined the phrase. "Then that language may be false." Which adds another dimension to this. Vivienne advised me to wait before filing. Not indefinitely. 4 weeks. She wanted to build the strongest possible case before the other side knew we were coming. I agreed. I was not in a hurry for drama. I was in a hurry for accuracy. During those 4 weeks, I did several things. I requested all correspondence between my father and Randall Frost's firm going back 2 years. As a named beneficiary of the original estate, I had the right to certain records. Frost's office was slow to respond, which Vivienne noted. I went through my own email and text history carefully and made a complete record of every communication I had with my father, with Diego, and with anyone at Frost's firm in the 18 months prior to the transfer. I organized it by date and saved it in 2 places. I also began watching Diego's public and social activity. I was not looking for anything specific. I was looking for the shape of things. For what the money had already become and how quickly it had become it, because both of those things would matter later. What I found in those 4 weeks was more useful than I had expected. Diego had moved quickly. Within 2 weeks of the transfer being finalized, he had made a substantial down payment on a property in the hills. The listing was public. The math was not difficult. Within 3 weeks, he had announced on his social accounts that he was launching a private investment fund and was accepting interest from qualified partners. The announcement used language that, to someone who did not know, might have sounded like he was the architect of this financial moment. There was no mention of where the capital had come from. I documented all of it. Screenshots. Dates. Saved copies. Vivienne had specifically asked me to track any spending or financial activity tied to the transferred assets. She had explained, carefully, that if Diego used the transferred funds in ways that constituted material commitment, it could complicate the eventual unwinding of the transfer if we prevailed. She was right. But she had also told me that evidence of rapid deployment could work in our favor in a different way. It demonstrated how urgently Diego had moved to claim the assets, which spoke to intent on both sides. I sent Vivienne the documentation on a Monday evening. Her response came the following morning. "This is useful," she wrote. "I think we are ready to file." The challenge was filed on a Wednesday. Vivienne had explained the process to me twice, carefully, so I knew what to expect and when. The filing went to the probate court that held jurisdiction over my grandfather's estate. It named my father as executor and challenged the transfer on 2 grounds: procedural violation of the notification requirement and misrepresentation of my knowledge in the transfer document. I was at work when it was filed. I had a site visit that afternoon and I went on it, walking the ground plan of a development with 2 engineers, because work had always been the best container for waiting. My father received the official notice by courier the following Friday. Owen called me that evening. Not on my father's behalf. On his own. Owen had worked for my father for 11 years and had also, quietly, been kind to me my entire life in the way careful people are kind inside difficult families. He said, "Your father received the court notice today. How did he take it?" I said. There was a pause. "He was quiet for a long time," Owen said. Then he asked me to call Randall Frost. I thanked Owen and hung up. Then I called Vivienne. My father called me the next morning. I answered on the 4th ring, deliberate. I wanted to be fully present rather than startled into it. "Isabella." His voice was controlled in the specific way that comes from years of practice. "You filed a legal challenge against the estate." "I did," I said. "Against your own family." "Against a procedurally invalid transfer," I said. There was a pause. "You are doing this out of spite." "I am doing this because the transfer violated the notification requirement in grandfather's estate plan. You know that requirement existed. You chose not to follow it." "I am the executor," he said. "I have the authority." "Your authority as executor is bounded by the terms of the document," I said. Vivienne Okafor has explained this in the filing. Randall Frost knows it too. Another pause. "You're making this a public matter. You made it a matter when you transferred my grandfather's estate without telling me," I said. "You started this." He was quiet for several seconds. When he spoke again, his voice had something underneath it I had not heard from him before. Not quite anger. Something colder. "This will damage the family," he said. "The family was already damaged," I said. "I'm just naming it." The first hearing was set for 6 weeks after the filing date. I wore a grey suit. Vivienne wore a dark blue one. We arrived 20 minutes early and sat at the plaintiff's table, and I watched the room fill in the way courtrooms fill, with a particular kind of purposeful quiet. My father and Diego came in together. Randall Frost sat beside them with his associate. 4 of them to our 2. I looked at my father once across the courtroom. He did not look back. The judge was a woman named the Honorable Patricia Tan. She had a reputation, Vivienne told me, for being impatient with procedural sloppiness. Vivienne presented our opening. She was precise and unhurried. She laid out 2 claims. First, that the notification requirement in the estate plan had not been met, and second, that the transfer document contained a false assertion about my knowledge of the redistribution. She asked the court to examine both. Randall Frost's associate, a man named Cole who had more confidence than experience, argued the transfer was within the executor's standard discretion. Judge Tan looked at him. The document contains an explicit notification clause. Can you explain the basis for overriding it? Cole hesitated. The judge made a note. I'll allow this case to proceed, she said. The second hearing was 3 weeks later. Vivienne had spent those 3 weeks preparing the evidentiary record with the care of someone who understood that our case was strongest on process, not on emotion, and who intended to keep it there. We presented 4 items. First, the original estate plan with the notification clause clearly marked. Second, the transfer document bearing my father's signature. Third, a complete record showing I had received no written notice in the 30 days before the transfer. Fourth, a declaration from an estate law specialist confirming the clause was binding and unsatisfied. My father's legal team presented one response, that my father, as executor, had broad discretionary authority, and that the notification clause was advisory rather than mandatory. The specialist's declaration addressed this directly. The clause used the word required. It was not framed as a recommendation. Marco's team had one other argument. They claimed I had attended a family dinner the previous year at which the future of the estate was discussed, and that this constituted informal notification. Vivienne produced the attendance records from that dinner. She produced the conference booking and hotel receipt showing I had been in another city that weekend. I had not been there. I could not have been. Marco's team had no response ready for that. The implied knowledge argument was their strongest card, and they played it at the third hearing. Their new attorney, a senior partner named Harmon who had replaced Cole after the second hearing, presented a package of communications. A text from Diego 16 months ago referencing Dad talking about restructuring things. A card I had apparently sent my father, which referenced the family's future plans. A note from a family gathering in which someone had written that the estate discussion was coming. I had kept my own records. Vivienne presented my response. The text from Diego had been a 2-word fragment in a long conversation about our cousin's wedding, and Diego had not explained or followed up on it. The card was a birthday card with standard language about the family's future, which Vivienne read aloud to demonstrate it referenced nothing specific. The note from the gathering was not in my handwriting and I had not been present when it was written. Then Vivienne presented my full message history from the 8 months before the transfer. Across 8 months of regular contact, neither man had once mentioned the estate or the transfer. Harmon had no clean counter to that. Judge Tan made a longer note that day. The fourth hearing focused on Diego's use of the funds. Vivienne had been careful about how she framed this. We were not there to accuse Diego of wrongdoing. We were there to demonstrate the scope and speed of the deployment, relevant to whether a rollback was practical. Diego was called to give a statement. He was not comfortable in that room. I could see it in the set of his shoulders and the way he held his jaw. He answered questions in short sentences, which was not his normal way. He confirmed the property purchase. He confirmed the investment fund announcement. He confirmed that both had drawn on the transferred assets. He said he had been advised by his financial consultant that the funds were fully his to use. Vivienne asked him one question that was not on the record beforehand. Did you, at any point, ask your father whether Isabella had been notified of the transfer before it was finalized? Diego was quiet for a moment. His jaw shifted. No, he said. I didn't ask. Why not? I assumed it had been handled properly. Vivienne turned to the court. The record shows the notification requirement was not handled properly, she said. And now we know that neither the executor nor the recipient verified that it was. Word had moved through the family by the time the fourth hearing concluded. I had not told anyone directly. I had not needed to. Legal filings are public record. My Aunt Celestine, my grandfather's youngest surviving sister, had found out through a contact of hers who knew someone at the courthouse. She called me on a Sunday evening. "I heard what your father did," she said. "You heard about the case," I said. "I heard about the transfer," she said. "And I heard about the case. I want you to know that I think you are right to do this." She paused. "Eduardo would have wanted you notified. He was specific about you, Isabella. He always was. Eduardo was my grandfather." Hearing her say his name in this context settled something I had not known was unsettled. Other calls came after Celestine's. Cousins. A former business associate of my grandfather's who had known our family for decades also reached out. My father called me after that wave of calls. His voice was different this time. Quieter. The controlled manner was still there, but something underneath it had changed. "People are talking," he said. "Yes," I said. "I didn't intend for this to become public." "I know," I said. "But you made decisions that affected other people. Decisions have consequences." Diego gave his formal deposition at the 5th hearing. He had a separate attorney by that point, which Vivienne told me meant Diego had begun thinking about his own position. The deposition was detailed. Vivienne had prepared 40 questions. She asked each one with the same measured pace, not rushing, not pressing dramatically, just moving through the record with the patience of someone who has built something solid and knows it will hold. Diego answered everything. He was honest. He did not try to construct a story that did not fit the facts. What emerged was the picture of a man who had accepted something valuable without asking whether the process was sound. He had not asked how the transfer was structured, had not read the estate plan, had not confirmed with anyone outside his father's circle that the process was clean. "I trusted my father to have handled it correctly," Diego said, near the end. "Did your father tell you that Isabella had been notified?" Vivienne asked. "He said it was taken care of," Diego said. "Did he specify what was taken care of?" Diego looked at the table. "No," he said. "He didn't." Vivienne let the silence sit for a moment after that. The courtroom was very quiet. The 6th hearing was the one that changed the room. Vivienne had saved the strongest legal argument for the moment when the court had been fully prepared to receive it, and I had trusted her judgment on that timing. She presented a precedent analysis, 3 cases in the past 12 years where probate courts had overturned transfers for materially violated notification requirements. In each case, the standard applied was whether the violation was procedural in form or substantive in effect. Did the missing notification actually affect the outcome, or was it a technicality with no real harm? In our case, she argued, the violation was clearly substantive. I had been given no opportunity to respond, challenge, or prepare. The 30-day window my grandfather had required was not a formality. It was a protection. A protection I had been denied. She also raised the language of the transfer document again. The phrase "the beneficiary having been informed" was not just inaccurate. In the context of a legally binding document, it was a misrepresentation. Judge Tan asked Marco's team directly whether they could produce any evidence that the phrase was accurate. Harmon said they would provide supplemental documentation. By the next hearing, the judge said. It was not a question. Harmon agreed. He did not look comfortable agreeing. I was given an opportunity to address the court at the 7th hearing. Vivienne had prepared me, which meant she had helped me understand what the court needed to hear and what it did not. Not an emotional account. A clear statement of what I had experienced and what the process had denied me. I sat in the witness box and spoke for 11 minutes. I described what the inheritance had represented. Not the money, though I was honest about the financial significance. The money was real and I did not pretend it was not. But more than the money, it was a designation. My grandfather had seen something in me worth naming. He had committed it to paper with full legal formality. He had believed in my capacity to manage something serious. What the transfer had done, beyond the financial removal, was erase that designation. I had been named and then unnamed without a single word. I said all of this quietly and in plain terms. I did not accuse my father of malice. What I needed was for the record to reflect what had happened. That a process existed to protect the people named in it. When I finished, the room was very quiet. Judge Tan looked at me for a moment before writing her note. Vivienne called me on a Thursday evening, 10 days before the final hearing. "We received something today," she said. Her voice had the particular tone of a lawyer delivering news that has more than one dimension. My father had submitted a settlement offer, 60% of the transferred assets returned to me, 40% retained by Diego, in exchange for full withdrawal of the challenge and a binding confidentiality agreement. I read the terms carefully. Then I read them again. 60%. Which meant they had concluded they were likely to lose the full case. If they believed they would win, they would not have offered 60%. They would have offered nothing. The confidentiality clause was the other telling element. They wanted this resolved without a public ruling. Without a court on record saying that my father, as executor, had violated the notification requirement. Without Judge Tan's words available for anyone to reference. "What do you recommend?" I asked Vivienne. "I never recommend on settlement," she said. "That is your decision. What is your assessment of our position at final hearing?" "Strong," she said. "We have the violation documented, the misrepresentation documented, and precedent for a full overturn." She paused. "But courts are not certain. 60% is real money." "I'll call you tomorrow," I said. I called Vivienne back the next morning. I had spent the night thinking about what accepting would mean. My father would never have to hear a judge say, in a public ruling, that what he had done was wrong. It would mean Diego kept 40% of something he had received through a flawed process and had deployed before confirming the process was sound. It would mean a confidentiality agreement that sealed the record from anyone who might, in the future, need to know what had happened. It would mean the truth stayed buried inside the family. I had spent my whole life watching things disappear into that space. "Tell them no," I said. Vivienne was quiet for a second. "Understood. Any response you want conveyed?" I thought about it. "Tell them I am not interested in a confidential settlement. If they want to resolve this, the resolution needs to be on the record." She confirmed she would send the formal response. Diego called me that afternoon. His voice was not angry. Something between resignation and anxiety. "Isabella," he said. "Are you sure about this?" "Yes," I said. He was quiet for a moment. "I didn't know it was done wrong," he said. "I know," I said. "I believe you. That doesn't change what happened." The final arguments were scheduled for a Friday morning. Harmon presented first. He had been a senior attorney for 20 years and he knew how to construct a closing argument from limited material. He argued that executor discretion was broad by design, the clause had been substantially complied with, and that correcting the flaw would cause more disruption than it warranted. He was skilled. I gave him that. Vivienne was precise. She began with the language of the clause itself. The word required, not recommended. Not encouraged. Required. She then presented the timeline, the exact dates of the transfer against the exact dates of any claimed notification, and showed the gap was complete. No contact. No notification. No 30-day window. Zero compliance with a required procedural step. She addressed the misrepresentation directly. The phrase "the beneficiary having been informed" was not ambiguous language. It was a specific factual assertion in a legal document. It was false. A legal instrument containing a false factual assertion about a named party was a serious matter. Not a technicality. She closed by citing the 3 precedents from the 6th hearing. In each of those cases, she said, the court found that a required notification is not optional. Required means required. Judge Tan wrote for a long time after Vivienne sat down. The verdict came on a Tuesday, 2 weeks after final arguments. I was in the courtroom. So was my father. So was Diego. So was Vivienne, sitting beside me with her hands flat on the table and her expression composed. Judge Tan addressed both sides before reading the decision. She noted that the case had been carefully presented and that the evidentiary record was clear. She said she had reviewed the precedents cited by the plaintiff's counsel and found them applicable. Then she read the decision. The transfer executed by Marco Crane as executor of Eduardo Crane's estate on 14 October was found to be procedurally invalid due to the executor's failure to comply with the notification requirement stated in the original estate plan. The requirement was mandatory, not discretionary. Its violation was material, not technical. The named beneficiary had been denied the opportunity to respond as the estate plan required. The transfer was overturned. The assets were to be restored to Isabella Crane within 60 days. The judge noted the misrepresentation and referred it for further review. I sat very still. Vivienne placed her hand on the table beside mine, not touching, just present. I looked at my father across the room. He was looking at the table in front of him. The room emptied slowly after the ruling. Diego left without speaking to me. He had the posture of someone trying to take up as little space as possible, which was very different from how he had moved through every room for the last 6 months. My father remained at the table for a long time. His attorney spoke to him in a low voice. At some point Harmon gathered his papers and left, and my father was alone at the table. I had been standing near the door with Vivienne, who was explaining the next administrative steps. Recovery of the assets, the accounting process, the review process triggered by the misrepresentation finding. At some point I looked up and my father was looking at me from across the room. He did not look angry. He looked something I had never seen on his face before. Not in 31 years of knowing him. He looked like a man who had understood the full cost of what he had done and found it was not the ruling or the assets. It was something no filing could restore. For the first time in my memory, he looked like someone who had made a mistake he could not manage around. I turned back to Vivienne and we walked out together. 3 months after the verdict, I was sitting in my grandfather's study. The room had been part of the estate. My grandfather's working space, filled with books and files. I had not spent much time in it before the legal process. Now, with the estate restored, it felt right to be there. I held the estate plan in my hands. The same document I had found in my filing cabinet on that Thursday evening when I came home from my father's office. The same document Vivienne had used in every hearing. My grandfather understood something my father had forgotten. That the people you trust will eventually reveal, through their choices, what they understand about trust. The test is what people do when they think the other person cannot see them. My father had thought I could not see him. He was wrong about that. I was not at peace with everything. I was not certain I would be. But I had learned something from the process. That being capable and quiet does not mean being without recourse. That the person who manages without complaint is not without standing. That what happened to me was wrong. And that wrong things can be corrected. I put the estate plan back in the folder and set it on the desk where it belonged.